the next matters on the docket today are State of Ohio versus Kaitlyn Renee Morales, two cases, 23 CR 383 and 24 CR 7. Would counsel into their appearance, please?
Justin Fry for the State of Ohio.
David Johnson, 00-92109, the actor's Rouse, seated to my right.
Very good. We are here for pretrial in both matters. However, we have had previous pretrial. The last pretrial was on, I believe it was February 2nd. At that time, I was informed about the new case and appointed Mr. Johnson to it and granted a continuance. Mr. Johnson, have you had an opportunity? Oh, I'm sorry. We were also here on March 4th, and at that time, I was told discovery was complete on both matters. Is that correct?
That's correct, Your Honor.
Very good. All right, so today I've been handed entry of guilty plea forms, leading me to believe that there is resolution in both of these matters. Mr. Johnson, do you have any concerns about your client's competence to enter a change of plea today?
No, Your Honor.
Any concerns about any possibility of Ms. Morales being under the influence of drugs or alcohol?
No, Your Honor.
Very good. Mr. Fry, would you state the terms of the change of plea?
Thank you, Your Honor. Starting with 2023 CR 0383, is my understanding Ms. Morales will withdraw her previously entered not guilty plea. She guilty plea to count 1, that being possession of cocaine. It's a felony of the 5th degree. That will be a joint recommendation for 6 months concurrent to 2024 CR 0007. I would also be requesting a nullity of count 2, it would be an illegal conveyance. In case number 2024 CR 0007, Ms. Morales will be withdrawing her previously entered not guilty plea. Enter guilty pleas to counts 2 and 3. We're requesting a dismissal of count 1. There'll be a joint recommendation for 8 to 12 years in total of all these, Your Honor. And just to be frank with the court, there was originally an agreement for the 2024 case before it was indicted to not indict Ms. Morales with that case, with her testimony, with her giving truthful testimony in the trial of Mr. Johnson. In regards to this incident, she gave testimony that was deemed not truthful and was not consistent with any other testimony that she has given, and during that time had taken responsibility for all the drugs.
Testimony?
Testimony. She testified in the trial of Mr. Johnson.
Was that in front of Judge Ferris?
It was.
And despite that, you are agreeing to dismiss the top count, the F1 possession cocaine charge?
Yes, Your Honor.
Let's see. Mr. Johnson, as you understand the agreement?
Yes, Your Honor.
You've explained to your client that this is a joint recommendation and the court's not bound by it.
I have, Your Honor.
Very good. Ma'am, you're Kaitlyn Morales?
Yes.
I have here in my hand 2 documents, both of them entitled entry of guilty plea, one in each of these 2 cases. In case number, plea form has, just clarifying the number, it's 383. In case number 23 CR 383, the form is telling me that you wish to plead guilty to count 1, the lower charge here of possession of cocaine, a felony of the 5th degree. That felony of the 5th degree carries a maximum possible penalty of up to 12 months in prison and a $2,500 fine. Do you understand this?
Yes.
This plea form appears to bear your signature on the back of it next to the word defendant. Did you in fact sign this form?
Yes, sir.
Before signing this form, did you read the form and go over it with your attorney?
Yes.
Did he answer all your questions?
Yes.
Are you satisfied with the job he's done for you?
Yes.
Given that you're happy with your attorney, he answered questions whenever this form you read and signed it, should I take from that you agree with what's in the form?
Yes.
For the record then, what's your full name?
Kaitlyn Morales.
What's your middle name?
I don't have one.
It's not Renee?
No.
Is your date of birth January 20th, 1996?
Yes.
And what are the last 4 digits of your social security number?
0734.
Counsel, you recognize this as her in the indictments?
Yes, Your Honor.
Very good. In case number 24 CR 7, the form is telling me that you wish to withdraw your not guilty plea and now plead guilty to counts 2 and 3. Count 2 is a charge of possession of a fentanyl-related compound, which is a felony of the 2nd degree. That felony of the 2nd degree carries what's called an indefinite prison sentence. In this case, the maximum possible penalty for that felony of the second degree is the indefinite prison term of 8 to 12 years. In addition, there is a maximum fine on that count of up to $15,000. You understand that?
Yes.
The form is also telling me that you wish to withdraw your not guilty plea and plead guilty to count 3, tampering with evidence of felony of the third degree. That felony of the third degree carries a maximum possible penalty of up to 36 months in prison and up to a $5,000 fine. You understand that?
Yes.
I'm sorry, up to a $10,000 fine. You understand that?
Yes.
Very good. Again, this plea form appears to bear your signature on the back of it. Did you in fact sign this form?
Yes.
Before signing this form, did you read the form and go over it with your attorney?
Yes.
Did he answer all of your questions?
Yes.
Are you satisfied with the job he's done for you in this case?
Yeah.
Very good. Are you currently on any, what, you said your full name is Kaitlyn Morales,
Yes.
and how old are you?
27.
Where do you live?
Currently?
When not incarcerated?
Oh. I live on Underwood.
Here in Marion?
Yeah.
How far did you go in school?
I did not graduate.
Okay. And do you read and write the English language?
Yes.
And I take it from our conversation here that you speak and understand the English language.
Yeah.
Are you a citizen of the United States?
Yes.
Are you currently taking any sort of prescription medication?
No.
Are you supposed to be taking any medication that you're not getting while you're incarcerated?
I mean, they prescribe me medicine in Marion, but won't give it to me tomorrow. But
What type of medication are you talking about?
depression medication.
Okay, this is medication you were taking before you were incarcerated?
Yeah.
Okay. Despite not having this medication today, do you understand what's going on here?
Yeah.
You got a clear head? Okay. Are you under the influence of any drugs or alcohol?
No.
Okay. Well, you and I are going to have a conversation here today. The whole point of the conversation is to make sure of 3 things. Number 1, that you understand the maximum possible consequences of entering these guilty pleas. Number 2, that you understand the rights you're giving up by pleading guilty. And number 3, that you're doing it all voluntarily. If at any time during this conversation you don't understand something I'm saying, I'm not explaining it well, or you just have a question and become confused, I want you to stop and either ask me or ask your attorney any question that you have. You're not going to be in any trouble for asking any questions, okay?
Okay.
All right. So we're going to start with that first thing, the maximum possible consequences. We've talked about some of these already. By pleading guilty in case number 23 CR 383 to count 1 of the indictment, the charge of possession of cocaine, a felony of the 5th degree, you subject yourself to the maximum possible penalty for that felony of the 5th degree. That could be up to 12 months in prison and up to a $2,500 fine. Do you understand that?
Yes.
Do you understand what that charge means, possession of cocaine?
Yes.
Did your attorney explain the charge to you?
Yes.
Mr. Johnson, are you willing to waive further explanation of the charge in case number 383?
So waived, Your Honor.
Very good. In case number 24 CR 7, the form is telling me that you wish to plead guilty to counts 2 and 3. Count 2 is the charge of possession of a fentanyl-related compound, which is a felony of the 2nd degree. That felony of the 2nd degree carries what's called an indefinite prison term, and what that means is that the court would choose a term from the range for a felony of the 2nd degree. That could be 3, 4, 5, 6, 7, or 8 years. And it would be rebuttably presumed that you would be released at that number. However, the Department of Corrections, the prison system, could hold a hearing based upon your conduct during any prison time and keep you up until 50% more of the sentence imposed in that case. So for example, if I chose the minimum sentence of 3, half of 3 is 1.5. The minimum sentence of 2, the range of sentences for a felony in the 2nd degree is 2, 4, 5, 6, 7, or 8 years. So the minimum sentence of 2, half of that is 1, so the minimum sentence range would be 2 to 3 years in prison, you understand?
Yeah.
If I chose the maximum number of 8, half of 8 is 4, 8 plus 4 is 12, so the maximum possible sentence for that felony of the 2nd degree is the indefinite sentence of 8 to 12 years in prison, you understand?
Yes.
In that case, there's also a maximum possible fine of up to $15,000 on that felony of the 2nd degree, you understand that?
Yes.
And I'm required to fine you at least half of that $7,500, you understand that?
Yes.
In addition, that charge has a mandatory component to it. Counsel, I'm confused by your plea form here. It says both that there's a presumption and mandatory prison on count 2.
Yes, Your Honor, count 2, there is presumption that it is prison. If she goes to prison, it's a mandatory time that she's not permitted to
Okay,
get
well,
additional.
that's not what the form is at, I understand what you were thinking, but the form is indicating whether it's required that I send her to prison. So in other words, it's not mandatory that I send you to prison on that case, but there's what's on that count, but there is what's called a presumption on that count. So in other words, when I start thinking about your sentence, when I think about sentences on any case, there's a couple of options, prison or probation. And usually the scales start out even, and then your past and the various sentencing factors weigh one direction or the other. But that charge, F2, possession of cocaine, possession of a fentanyl-related compound, I'm supposed to start out thinking send you to prison. That does not mean that your attorney could not present evidence that could tip the scales back in favor of probation. You understand how that presumption works?
Yeah.
Okay. All right. Counsel, you satisfied that your client understands that?
Yes, Your Honor.
I guess the other thing about the plea form then, if it's only a presumption, that doesn't mean that she isn't eligible for community control, and community control box is not checked on the form.
Apologize, Your Honor.
Very good. I'm going to check that now. Any objection?
No, Your Honor.
All right. With regard to count 3, the tampering with evidence charge, it's a felony of the 3rd degree. It carries a maximum possible penalty of up to 36 months in prison, and also a maximum possible fine of up to $10,000. Do you understand that?
Yes.
Do you understand what that charge means, tampering with evidence?
Yes.
Did your attorney explain that charge to you?
Yes.
Did he explain the possession of a fentanyl-related compound charge to you?
Yes.
Mr. Johnson, are you willing to waive further explanation of the charges in case number 24 CR7?
So waived, Your Honor.
All right. Then I think the only other thing you need to know, ma'am, is that these sentences could be run either concurrently or consecutively to each other, meaning that they could be run at the same time or they could be run back to back to each other. That's what consecutive means. So if you were to receive a maximum consecutive sentence in this case, then 8 plus 3 for the felony of the 3rd degree plus 1 for the felony of the 5th degree is 12. You would still have the tail, the indefinite sentence of 4 additional years. So the maximum possible penalty here for all of these sentences, if you received a maximum consecutive sentence, would be 12 to 16 years in prison. Do you understand that?
Yes.
Okay. And the maximum fines then could be a total of $17,500. You understand this?
Yes.
All right. Counsel, you satisfied with those explanations of the maximum possible penalties?
Yes, Your Honor.
Very good. All right, Ms. Morales, have you ever been to prison before?
No.
So you're not on any sort of post-release control or parole?
No.
Well, in these cases, if you are sent to prison, upon your release from prison, you would be subject to post-release control. For the felony of the 5th degree in case number 3A3, it's optional of up to 2 years. And for the felony of the 3rd degree in case number 24-7, it is also optional. However, the felony of the 2nd degree is mandatory. The adult parole authority would supervise you for at least 18 months and up to 3 years. During that time, you'll have to follow their rules. If you violated any of their rules, they could place more restrictive sanctions upon you, up to and including sending you back to prison for up to half your original sentence, no more than 9 months at a time. In addition, if you were to commit a new felony while on post-release control, the next judge could not only incarcerate you for that new felony, but could also give you either 12 more months or the rest of your days on post-release control, whichever was longer. You understand?
Yeah.
All right. Now, on the other hand, I could technically give you community control, or what most people call probation in these cases, as nothing here is required that I send you to prison. However, you understand that probation can last for up to 5 years. During that time, you'd have to follow their rules. If you violated their rules, they could place more restrictive sanctions upon you, including they usually do things like make you take classes, do community service hours, be on house arrest, but they can do more serious things like send you to a treatment facility, even a locked treatment facility, for several months at a time. If your violation were severe enough, however, they'd bring you before me, they'd ask me to revoke your probation and send you to prison. If I had to do that upon your release from prison, you would once again be subject to post-release control, or the things I already told you about post-release control would still apply. In other words, the adult parole authority would supervise you. And if they did on these matters, because of that felony of the second degree, they would supervise you for at least 18 months and up to 3 years. And during that time, you'd have to follow their rules. If you violated any of their rules, they could place more restrictive sanctions upon you, including sending you back to prison for up to half your original sentence, and if you committed a new felony while on post-release control, the next judge could not only incarcerate you for the new felony, but also give you either 12 more months or the rest of your days on post-release control, whichever was longer. Counsel, have I neglected anything with regard to maximum possible consequences?
No, believe so, Your Honor.
No ways, Your Honor.
I believe that covers it all as well. So I'm going to move on to the second thing that I told you I need to make sure of, and that's that you understand the rights you're giving up by pleading guilty. And these rights I'm going to talk to you about, they apply equally and separately in each of your cases. So for example, I'm going to tell you that you have the right to a trial, or you have the right to a trial in each of these cases. So all the rights I'm going to talk to you about apply in each of these cases separately, understand?
Yes.
Okay. You do understand you have a right to a trial.
Yes.
You understand what we're doing here today is not a trial.
Yes.
If you wanted a trial, you could try your case to me or to 12 jurors that would sit over here in my jury box. Those jurors would be selected from our public with the help of your attorney. And in order for you to be convicted, in order for you to be found guilty, all 12 of those jurors would have to agree that the state of Ohio, the prosecutor there, had proven his case to the highest standard we have under the law, a standard called proof beyond a reasonable doubt. Do you understand you're giving all that up by entering this guilty plea?
Yes.
Very good. You're also giving up your right to remain silent. You see, during that trial, no one could make you testify. You could if you wanted to, but no one could make you testify. And if you chose not to testify, no one would be allowed to comment on your silence or use it against you in any way. Do you understand you're giving up your right to remain silent by entering these guilty pleas?
Yes.
It's a very real thing, because the first thing I'm going to do is order a pre-sentence investigation, a report to help me decide what your sentence should be. And as part of that, you'll be interviewed about this crime. You'll be expected to answer honestly, because you're giving up your right to remain silent. You understand? You're giving up your right to remain silent by entering these guilty pleas.
Yeah.
Very good. You're also giving up your right to see and hear all the state's evidence against you. That evidence would be presented right here in open court. There wouldn't be any secret evidence. And just as importantly, you're giving up your right to have your attorney stand up, cross-examine, question, and confront the state's witnesses against you. Do you understand you're giving up these important legal rights?
Yes.
You're also giving up your right to subpoena any evidence that you might have. Now, don't get me wrong, you don't have to present any evidence in this case. You do not have to prove anything. The state brought the charges. They're the only ones that have to prove anything. And if they fail to prove their case would be dismissed. But if you wanted to present evidence, I would help you do it. I would issue subpoenas, court orders for your witnesses. We would serve these subpoenas on your witnesses. We would make them come to court and testify. When you plead guilty like you're doing now, you give up that subpoena power. You understand?
Yes.
You also give up any possible legal defense that you might have to these charges. Sometimes under the law, there are defenses. Things like an alibi, that you were at some other place in time when this crime occurred, or that you did it under what's called duress, like the threat of great bodily harm, like someone held a gun to your head and said, possess these drugs or else. There are many defenses under the law. Mr. Johnson is an excellent attorney who is trained in these defenses, and if any of them applied in this case, he would have talked to you about the possibility of winning your trials with one of those defenses. What's important for you to understand here today is that when you plead guilty, like you're doing now, you're telling me you're guilty. You are asking me to find you guilty, and you are giving up your trials. And those trials are the only place that you can put forward a defense. You understand you're giving up your trials and your defenses by entering these guilty pleas.
Yes.
Very good. You're also giving up just about all of your appellate rights. You see, if this case did go to trial, and you lost that trial, you were found guilty at trial in one or both of these cases, well, you could appeal those guilty findings to 3 other judges on the Court of Appeals. You could even appeal my rulings as judge and many of the things the attorneys might have said or done during those trials to those same 3 judges on the Court of Appeals. When you plead guilty like you're doing now, you give up your trial, so you also give up your right to appeal all the things that might have happened during your trial. As a matter of fact, about the only thing left to appeal after a guilty plea like this is if I were to try to give you some sort of unlawful or illegal sentence. So for example, I've told you that the maximum possible sentence maximum possible consecutive sentences here is the indefinite sentence of 12 to 16 and a half years, or 16 years in prison. You understand, if my sentencing entry came out and said life without parole, you could appeal that sentence and you would surely win. That would be an unlawful sentence. It'd be more than I was allowed to give you. It wouldn't matter if I just made a mistake or got angry and tried to give you more time than I was allowed to. Either way, you could appeal that sentence and you would win. As long as I give you a lawful sentence. 12 to 16 years total or less, or probation, you're pretty much giving up all of your appellate rights by entering these guilty pleas. You understand?
Yes,
Still want to go forward with the pleas.
yes.
And I just need to make sure of one more thing, and that's that you're doing all this voluntarily. Has anyone threatened you in any way in order to get you to plead guilty here today?
No.
All right. Now, I know there's what's called a jointly recommended sentencing recommendation in these matters. In other words, in case number 383, the felony of the 5th degree, the attorneys are going to tell me at your sentencing hearing that I should impose 6 months concurrent to the sentence on the other case, meaning at the same time. And in case number 7, the parties are going to recommend that I impose the indefinite sentence of 8 to 12 years in prison. You understand, of course, that those are just recommendations, and even though the attorneys both agree on what they believe the sentence should be, that it's not a promise that that's what your sentence will be.
Yes,
That your sentence is entirely up to me, you understand that?
yes,
And so just because they both ask for it, just because they both write it on this form, and just because everyone signs it, it's not a promise that that's what your sentence will be.
yes.
You understand? And you understand that I haven't promised you anything, have I?
No,
Has anyone promised you anything then in order to get you to plead guilty here today?
no,
Are you pleading guilty because you are guilty?
yes.
All right. Miss Morales, do you have any questions for me?
No.
Then I've got some questions for you. In case number 23 CR 383, how do you plead to count 1, possession of cocaine, a felony of the 5th degree?
Guilty.
And in case number 24 CR 7, how do you plead to count 2, possession of a fentanyl-related compound, a felony of the 2nd degree?
Guilty.
And in case number 24 CR 7, how do you plead to count 3, tampering with evidence, a felony of the 3rd degree?
Guilty.
Thank you. Statement of facts.
Thank you, Your Honor. Starting with 2023 CR 0383, on or about June 5th, 2023, a traffic stop was conducted on North Greenwood Ave near Corey Street here in the city of Marion County, Marion, Ohio. The driver of that vehicle was identified as Kaitlyn Morales. She was subsequently arrested on warrants and transported to the Marion County Correctional Center, the Multi-County Correctional Center, I apologize. A search when she arrived revealed a baggie containing powder in her bra that was sent to VCI for testing and came back as 0.97 grams of cocaine. In case number 2024 CR 0007, on or about August 5th, 2022, a traffic stop was conducted on Urban Shoots Road near Goodnow Road here in Marion County, Ohio, on a vehicle being driven by Mr. Myron Johnson. When they got the individuals out of the vehicle, they were separated. Ms. Morales informed officers that she had drugs on her person. She told them that Mr. Johnson had given her the drugs, told her to hide them. Then she testified at the trial of Mr. Johnson, and in her testimony, she told the court and the jury that she did not know whose drugs they were. She grabbed them from the center console to save herself, and no one told her to hide those drugs. Those were sent to the Mansfield Crime Lab for testing, and in those was 19.24 grams of fentanyl and heroin.
All these events occurred in Marion County in the state of Ohio.
They did, Your Honor.
Mr. Johnson, any exception to the statement of facts for purposes of today's plea?
No, Your Honor.
And so are you satisfied with your client's decision to enter these pleas? Do you believe she's doing them knowingly, voluntarily, and intelligently with a full understanding of her legal rights as well as the potential consequences of the pleas?
Yes, Your Honor.
Very good. Counsel, I have modified the plea form in case number 24-7 because the mandatory language there is about whether a prison sentence must be imposed. It actually reads, I will not be eligible for community control, which is, I understand what you meant, Mr. Fry, but that's a different kind of mandatory than the form's talking about, so I've voided that out. I'm going to ask you all to come initial that and have Ms. Morales and make sure she understands that. And just for the record, what Mr. Fry is referring to is whether or not if sent to prison, every day has to be served mandatorily, day for day, as opposed to some sort of early release situation.
Yes, Your Honor, the statute says they may impose a mandatory term, not shall impose a mandatory term.
I understand what you were thinking, but the rest of the rest of that sentence is talking about is not eligible for community control, so that's talking about whether I must impose a prison sentence or I have the discretion to impose community control. Thank you. Record reflect that the council's gone over that adjustment to the plea form and it's been initialed by the parties. Court watch that happen. All right, so I agree. Ms. Morales and I have had a good conversation here today. She's looked me in the eyes, listened attentively, answered my questions, answered them appropriately. Because of that, I believe she knows what she's doing. She's doing it voluntarily and intelligently, and I find such, and therefore accept her guilty pleas and find her guilty in case number 23 CR 383 of count 1, possession of cocaine, a felony of the 5th degree. And in that case, we'll also, at the request of the parties, dismiss count 2, illegal conveyance, a felony of the 3rd degree. In case number 24 CR 7, the court finds the same, and therefore accepts Ms. Morales' guilty pleas and finds her guilty of count 2, possession of a fentanyl related compound, a felony of the 2nd degree, and also of count 3, tampering with evidence, a felony of the 3rd degree. And again, at the request of the parties, despite Ms. Morales' backing out of the apparent agreement that they had, the court is going to, at their request, dismiss count 1, possession of cocaine, a felony of the 1st degree. Having done that, I'm going to set both these matters for sentencing. I need about 3 weeks to do that. Counsel, are you available on Friday, April 26th?
Does the court have any availability first thing in the morning?
I'm available at 8:30.
8:30 works, thank you, Your Honor.
Go ahead and set disposition in both cases on Friday, April 26, 2024 at 8:30 a.m. I'm going to order a pre-sentence investigation. Are there any other evaluations the parties are requesting?
No, Your Honor.
No, Your Honor.
I'm going to revoke bond, given that there's a presumption for prison in these matters and a joint recommendation for prison. Anything else, counsel?
No, Your Honor. Thank you.
Nothing, Your Honor, thank you.
Ms. Morales, what's going to happen here is my staff's going to come out to the jail and interview you. This report that I talked to you about to help me decide what your sentence should be, we call it a pre-sentence investigation. It tells me about you, your past this crime, and your hopes for the future. It's an important document under the law because the law in our state says without this document, I can only incarcerate you. I cannot give you probation. And it's very important because it helps me decide, even if I do incarcerate you, what that sentence should be. Your behavior between now and the next time I see you on April 26th is also very important. If you're getting in trouble in my jail, that's not going to reflect very well on your sentence. Counsel, is there anything else we need to discuss today?
No, Your Honor. Thank you.
I don't believe, Your Honor, thank you.
That'll be all.